Welcome back here with Money, 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 and this week we're talking about the importance of having a will in place. So we've got a query that came in from one of our viewers, Mr. S. Ramchand. Now, he's got two separate questions that I want to sort of toss to you, gentlemen. He's asking that if a will is registered, then is a succession certificate still necessary? Why should people go through all the trouble of going to the courts and taking old parents to courts, etc.? So he's saying, if I've registered my will, do I still need a succession certificate?
So, Surabhi, I think there's a little bit of confusion there. These two things are not connected.
Okay.
Registration is an optional choice. If you wish to register, go ahead and register. Succession certificate is a document that gets triggered when somebody goes away without a will. So, when somebody goes away without a will, how does the court know, or how does the society at large know who is now the legal heir to your property? So therefore, the legal heir or the person representing all the legal heirs, one of the legal heirs, would make an application to the court to say that please identify me as the legal heir and give me a certificate to that effect so that I can go to the various institutions and get the inheritance in my favor. So that is what a succession certificate does. So if somebody goes away without a will, then you need succession certificate or letters of administration, which is the other terminology used. But otherwise, if you have a will, then you need a probate.
Okay, fair enough. Now his second question, and this one's really interesting because this seems to be hinting at some sort of a dispute which arose despite there being a will in the family. So he goes on to say that my cousin's father had submitted a nomination to the society nominating his daughter for the flat after his demise. There existed a will echoing the same wish as well. But the society refused to transfer the ownership of the flat in the daughter's name. He claims it was owing to pressure from some of the other family members, including brothers. And he says that even the registrar of societies gave a ruling against the daughter. She could not get a succession certificate either. The brothers apparently claim that the father was mentally unsound. So obviously this is a situation where there was a will, there was a nomination as well to this particular apartment in the lady's name, but it didn't go her way. So what are the lessons one can learn
again,
from this?
one of the common things all the time you'll see whenever there is a dispute, the first claim is that the signature is forged, the will is forged, the person who's written the will was of an unsound mind. Therefore, again, same point that you have to write the will well. Had he attached, let's say, a medical certificate from a leading doctor saying that when the person wrote the will, he was in sane state of mind, that could have taken care of this problem. Had he videographed the proceedings of writing the will, then it means it is not forged. So all that I'm saying that
number one, make sure that you record the will in camera.
Exactly.
Attach a medical certificate.
That's right.
Any other points, Kartik? Because this is very important. There's no point having a legal document unless and until it's reasonably sort of strong and it can hold scrutiny in these challenges.
The two witnesses who are going to be witnessing your will have to be there, and you must sign in the presence of these witnesses.
Okay, that's point number 3.
Because a lot of times you'll sign it and send it to the witness later on. Somebody will sign it later on. So that person has not really seen you. If a testimony is actually required, then the witness will be 100% confident to say, yes, I saw this person signing it in my presence. So I think that's very important. And the other point, very important, is the executor. So if whether you appoint one person or two people, that is a matter of your choice, but you can even do 2 or 3, but just make sure you appoint one, because if you don't appoint an executor, then you pretty much have to go back to the court to say, please now first appoint an executor and then start the procedure.
But for instance, in this particular case, had there been a proper executor of the will in place, how would the situation have been avoided where the property was sort of supposed to go to the daughter? That's what the will said, but then there was a challenge from other family members.
So in this case, to my understanding, the society is just acting completely irrationally, and they are probably under pressure, and maybe they don't understand the law themselves. They have no business to decide who is the owner of the property. Society is meant to run the affairs of the society and the building. So therefore, if the society has a nomination, they must transfer it. There are already established judgments to this effect that you must transfer it to the name of the nominee. Now let the family members figure out who is the legal title owner.
The other points we were just discussing, that let not will surface after the death of the person. It suddenly springs out from some drawer that there was a will. Let the world know, let your family know. We as Indians generally have this tendency of not discussing money matters in public. I think we need to do that more. We need to discuss this with our children, and people should be aware that whom am I leaving what behind for.
I think it's a really apt point that you've made. A lot is changing in the way we live our lives, in the way social norms are, and it's about time perhaps some of that changes when it comes to our money as well. Gentlemen, thank you so much for joining in. Great to have this conversation. Very, very informative. That's it on this week's episode of Money, Money, Money. In case you have any feedback, comments, questions, queries, do keep writing in. Our email ID is on your screen. We'll see you again next week.